So what the focus of today's presentation is going to be how to help tenants prepare their legal documents online to fight their eviction. So these are really the big ticket things I want you to take away. We have a lot more to cover, but I want to hit this right out front. Really, we want to get this message out to tenants that if you are eligible, sign the declaration and give it to your landlord. There is no downside to this. There is no sense in waiting. There is no reason to wait. And if you haven't, and there's no time limit. So if you haven't, you still can. Make sure for tenants, they need to keep a copy of that declaration for themselves, give a copy to the landlord, but keep a copy for themselves. They also need some kind of proof of service of how and when they gave it to their landlord. So on our declaration form available on our website, there's actually a proof of service form that the tenant can fill out when they give the declaration to their landlord, saying how they delivered it, to whom they delivered it, when they delivered it. So the tenant will keep both of those things, because if the landlord should move for eviction, the tenant will want to submit those in their court case to show the court that they have taken this action. Okay, so that's the first thing. The second thing is, if the tenant receives an eviction notice, they must take some action and file with the court. A lot of tenants are thinking that, well, I gave the CDC declaration to my landlord, so I don't need to worry about this eviction notice that just got posted on my door. That is absolutely incorrect. And I'll explain more about why that's incorrect. But if a tenant takes no action, they could get evicted automatically. So they have to file this answer with the court in response to that eviction notice to tell the court that they intend to fight this eviction. And that answer form is the form that we are going to talk about creating today. There's a link to the CHAPS application on our website as well. Okay, so now let's dive into evictions a little bit. So every eviction in Nevada starts the same way. It starts by the tenant receiving a notice that tells the tenant what the problem is. This is the reason the landlord wants to evict you. That notice can be put on their door. Sometimes they receive it by mail. Sometimes it's actually handed to them. But that's the way the eviction process starts. Now, there are really two types of notices. There's a one-part notice, meaning the tenant will receive one document, and that's the only notice they'll receive. And there are two-part notices, meaning the tenant will receive two separate documents over a span of time. All of the notices are for different reasons and have different time periods. So the one-part notices, the big one you'll see is the notice for non-payment of rent. That is a 7-day notice. The tenant will receive one 7-day notice, or they may receive a 30-day notice of non-payment of rent if the property is covered by the Federal CARES Act, meaning that it's got a federally backed mortgage or it participates in a federal housing program. So those notices, they are one-shot notices. The other one-shot notice is a 5-day unlawful detainer notice if the tenant's lease has expired. This is pretty rare, but a landlord can, immediately after a lease expires, serve a tenant a 5-day unlawful detainer notice to get the eviction process started. Now, importantly, both of these notices, in the notice themselves, it will tell the tenant, you need to respond to this notice within this time period. So if the tenant reads the notice, it will be really clear. Now, the other parts of the other types of notices are the two-part notices. So the first part of each of those notices basically just tells the tenant, this is what the problem is, and I want you to leave. Either sometimes they get to fix the problem, but basically it's this is the issue and I want you gone. The second part of the notice is called an unlawful detainer notice. And that notice essentially says, I already gave you this other notice and you didn't leave the property. So now I'm giving you this unlawful detainer notice saying you're unlawfully on the property and I'm going to move to evict you and you need to take action to prevent that. Okay, so we'll talk a little bit more about that, but these are the two-part notices. A no cause notice is a notice that the landlord gives, basically just saying, you haven't done anything wrong, I just want my property back. Importantly, this notice can only be given if there's no lease agreement. If there's a valid current lease agreement, that contract protects the tenant. But once that lease agreement expires, the landlord can serve a no cause notice to try to get the property. So there are two no cause notices. If the tenant pays rent monthly, they could receive a 30-day no cause notice. If they pay rent weekly, they could receive a 7-day no cause notice. That's the first part of the notice. Once those time periods run, the tenant will receive a second part of the notice, which is the 5-day unlawful detainer notice. And that notice will tell the tenant, you have 5 days to fight this eviction. Go to the court, file something to fight this eviction if you're going to. Okay, so the next two-part notice is a tenancy at will notice. These are pretty rare. You probably won't see this very often, but a tenancy at will notice is really used for guests, kind of. So let's say I invited somebody to stay with me, and now they're refusing to leave. That person is a tenant at will, and I can evict them on a tenancy at will notice. So that's a two-part notice. They would receive a 5-day notice telling them to get out. If they don't get out, they would receive the second 5-day notice, which would say, you're unlawfully on the property, and I'm going to move to evict you, and you have the right to file an answer. The third notice we're going to talk about is a nuisance notice. A nuisance notice is used when the tenant is doing something wrong on the property. They're conducting some illegal activity, they are damaging the property in some way. That is a 3-day notice that will say, this is what you're doing that I don't like. Then there's a 5-day notice that says, I told you, I wanted you gone, you're still on the property, you have 5 days to fight this if you're going to. The last notice is a lease violation notice. A lease violation notice is a 5-day followed by the 5-day unlawful detainer. The first 5-day will say, this is how I believe you are violating your lease. Now, importantly, with the lease violation, the tenant actually has an opportunity to fix that, if they can fix it. The landlord says, you're violating the lease by XYZ. And tenant does XYZ. They fix XYZ. That should avoid the eviction. But if they get the second part of that notice, the second part is the same 5-day unlawful detainer notice that says, I told you there was a problem, you're still on my property, I want you gone, you have 5 days to file something with the court. So notice that the second part of this notice is the same for all these notices. It's the notice that says you have 5 days to file with the court. Okay, so this, I know you can't see it, it's really small, but this is the first part of the notice of the 5-day notice because the tenant has violated the lease in some way. 5-day notice to perform lease condition or quit. So if you can see my cursor, there's a couple of things I want to show you that are important on this form. Now, this is the form from the Civil Law Self-Help Center. The form that the tenant actually may receive may look a little bit different than this. The landlord might create their own form, but statutorily under Nevada law, the form has to contain certain information. All right, so here, this is going to be the tenant's name and address. This is the landlord's name and address in this section. Now that's important because when you're filling out the answer form that Lauren and Ryan will talk about later, you want to make sure that the tenant is telling you what information is on this form. They may deal with Fred in the office, but Fred's not the person who's going to be on this notice, probably not. So, so that's important. The other thing I want to point out, all right, so down here, there's a space for date of service. On the first part of this notice, that's not too important, but it is important on the second notice. All right, so the tenant will receive, let's say the tenant violates their lease, they would receive this 5-day notice to perform lease condition. It basically says, you have violated your lease, you have 5 days to get off my property or fix this condition. So the 5 days run, landlord is still unhappy with the tenant and wants to move forward with eviction. So the landlord would serve the second part of the notice. So this is the second part of the notice. This is the 5-day notice of unlawful detainer. And this is the same notice that the tenant would receive for all those two-part notices. And what it says is, you received a notice, you didn't do anything, you are now guilty of unlawful detainer. You're unlawfully detaining the property. And so I am going to move to evict you. You have 5 days to go to court and file an answer to fight this eviction if you're going to. If you don't, the eviction could be granted automatically. Now, on this form, as I said, there's going to be a date of service. That's important because that's how you know how to count the 5 days. So after the 5 days pass, the tenant has no right to file an answer to fight this eviction anymore. So counting the days is important, and we'll talk about that a little. All right, so one-part notices, which is basically the big one, is the non-payment of rent. It's a 7-day notice for non-payment of rent. The tenant can answer during that period, during the 7-day period, until the court closes on the last day. The two-part notices, the tenant would let the first part of the notice run, then the tenant would receive the second part of the notice. Only during that second period can the tenant file with the court. So the tenant cannot file during that first period. They have to let that first notice run. When they get the second, they can file with the court. So timing is crucial. So the way you count that time period is by counting judicial days, which are basically days that the court is open. So right now, the justice courts where evictions take place are open Monday through Thursday. So you don't count the day the notice was actually delivered to the tenant. You don't count that day. You don't count Fridays. You don't count Saturdays, and you don't count legal holidays. So let's say, for example, a notice was served, a 7-day non-payment notice was served on the 3rd. So you wouldn't count the 3rd. The 4th would be day 1. This is a holiday, so you don't count that. You don't count Friday, you don't count Saturday, you don't count Sunday, because the court's closed. So don't count date of service. Next day would be day 1, day 2, day 3, day 4, day 5, day 6, day 7. I hope that makes sense. If you ever have a question about how to count the notice, you can always call our office and we'll try to help you walk through the notice. But again, it's pretty simple. Don't count the date that the notice was served. The next day is day 1, and you only count the days the court's open. Eviction starts with a notice, then what happens? So what we're going to talk about today is the summary eviction process. This is the process by which an eviction moves through the court. So it's called the summary process because it is. It's fairly quick, it's fairly easy, it's really designed so that landlords will be able to do this on their own. But it's also designed so that tenants will be able to appear on their own. So it's pretty rare that you actually see a lawyer in eviction court, for example, because tenants and landlords are appearing themselves. So one thing to note about summary eviction, it's only about possession. So even if the landlord is evicting for non-payment of rent, and the landlord says, you owe me $7,000 in back rent, the only thing that the court can do in summary eviction is say, tenant, you're being evicted, and landlord, you get the property. It does not award money. So the landlord would have to sue separately for money. All right, so all summary evictions, as we said, start by the tenant getting an eviction notice. They will get the eviction notice that relates to the reason that the landlord thinks they'll be able to evict. So to avoid eviction, during that notice period, the tenant has to file an answer. Sometimes it's called an affidavit, but we'll call it an answer. That's generally what it's called. The tenant has to file an answer with the court in order to protect themselves and basically notify the court that I intend to dispute this eviction. After the tenant files the answer form, or after the time for the tenant to file the answer form is passed, then the landlord can file a complaint for eviction. So it's a little weird because the person being sued, the tenant, is the one who actually files first, and then the landlord files second. So during the notice period, tenant can file. After the notice period, the landlord can file and say, I want an eviction. So if the tenant didn't file during that period, what happens? If the tenant didn't take any action, didn't file anything with the court, then basically the eviction gets granted automatically. It's called a straight eviction, and it's eviction that's granted without a hearing. The court just looks at the paperwork and issues the eviction order. The eviction order gets sent to the constable. The constable will post that order on the tenant's door and will return in 24 hours and lock the tenant out of the property. So that's if the tenant didn't do anything to protect themselves. Now, what happens if the tenant did file an answer? Filing an answer guarantees the tenant a hearing in front of the judge. So nothing can happen until that hearing. And importantly, it doesn't even matter what the tenant says in the answer. There are a lot of defenses that the tenant might be able to raise depending on the type of notice that they received and the situation, but it doesn't really matter what they say. As long as they get an answer on file, they are guaranteed a hearing in front of the judge. So when the landlord files the complaint, a hearing will be scheduled. This court will send out a notice of hearing that will have the hearing date. Now, a new development that we've been working on is eviction mediation. So this mediation only applies if the tenant receives a non-payment notice. So if the tenant receives a notice of non-payment, when they file their answer with the court within that 7 days, they will be able to elect mediation. They say, I want to participate in the mediation program. And that case, the hearing in that case will be set out 30 days so that there's time enough for a mediation to take place. The tenant will be notified of the mediator. They will need to register online with the mediation program that's being run through the state, and they'll receive instructions on all of this. But basically, they'll have an opportunity to sit down with a mediator, the landlord, the tenant, and a neutral mediator sit down to see if there's some way that they can work out an arrangement to keep that tenant in the property, whether that's repayment of back rent, whether it's some other creative solution. Potentially, it's rental assistance through CHAPS. So if you are assisting a tenant who has received a non-payment notice, they should elect mediation. There is no downside to mediation. If it doesn't work, it doesn't work. No harm, no foul. But it might, and it extends the eviction process out. So if a tenant does file an answer, as I said, they get a hearing. The hearings are pretty informal. It's usually the landlord, the tenant, the judge, and really what the judge is trying to determine is whether the tenant has a legal defense to that eviction. If the tenant, so if the tenant doesn't have a legal defense, or let's say if the tenant does have a legal defense, then the eviction will be denied. Meaning that the landlord does not get the eviction, the case will be automatically sealed in 10 days so that other landlords can't see it. And the landlord really then has a couple of choices. They can either they could appeal, or they could pursue the formal eviction process, which is a totally another process we're not going to talk about, or they could just wait and serve another eviction notice to the tenant and start the whole summary process all over again. So that's if the eviction is denied. If the eviction is granted at the hearing, that means that the judge will issue an eviction order. It will go to the constable. The constable will post it on the tenant's door. The constable will come back in 24 hours to lock that tenant out of the property. Now, before that lockout happens, well, let me step back. If the lockout happens, the tenant's done. There's no way to get back in the property. There's nothing the tenant can do. to save that tenancy. But before the lockout happens, there are a couple things the tenant can do. The tenant can file a motion to set aside, which is basically the tenant telling the court, I think there was some legal mistake made. I have a legal reason that this eviction shouldn't have been granted. Those can be a little tough for a tenant to win. It's not super common, and it doesn't necessarily stop the eviction. It can stop the eviction if the tenant raises some legal reason that the judge wants to talk to the tenant about. The judge can set a hearing and stop the eviction process until that hearing, but it's not guaranteed. The other thing a tenant can do is file a motion to stay. Now, a motion to stay is really a motion to get a little bit more time on the property. So it's not a motion to permanently stay on the property, it's a motion to delay leaving. So all the court can do on a motion to stay is grant the tenant up to 10 additional days to leave the property. The court doesn't have to grant anything. It could deny it and the tenant will get nothing. Or the tenant could the court could give any number of days up to 10. The other thing that a tenant can do is appeal. Now, all evictions are heard in the justice court. An appeal is the tenant saying, I believe this decision is wrong. I'm going to appeal it to the next highest court, which is the district court. To appeal, there is a $97 filing fee. If the tenant has filed a fee waiver saying I'm indigent and I can't afford this filing fee, that filing fee can be waived. Importantly, though, there's also a $250 cost bond that the tenant has to pay. So the tenant literally has to give $250 to the court clerk. That money is the thing that stops the eviction until there is some decision on the appeal. So appeals can be very effective, but it's hard for tenants sometimes. If the tenant is having a really hard time paying their rent, then it's really hard for them to justify coming up with $250 to pay the district court. But that amount can't be waived, and that's the thing that stops the eviction. Okay, so that is basically the summary eviction process from start to end. So just to go over it one more time, every eviction starts with a notice. The notice is served to the tenant. Within that notice period, the tenant can file an answer with the court. That's where you all will hopefully come in and help tenants so that they can prepare that answer with the new online program and get it filed. After the notice period runs, the landlord can file a complaint for eviction, asking the court to issue an eviction order. If the tenant has filed an answer, then a hearing is going to be set. If the tenant hasn't filed an answer, then a straight eviction can be granted. Tenant doesn't get a hearing, eviction's automatically issued. If the tenant receives a non-payment notice and has requested mediation, mediation may be built in there somewhere. If the tenant has filed an answer, there will be a hearing set where the judge will either grant the eviction or deny the eviction. If the eviction order is granted, it will be sent to the constable. The constable will post it on the tenant's door, will come back in 24 hours to lock out the tenant. Before that lockout happens, the tenant can try filing a couple of different types of motions, or the tenant can appeal. Once the lockout happens, the eviction's over and the tenant's done.